Hi everyone, you're watching the virtual Amicus and I'm Jay Lodha. Well, doing a PhD while practicing law, what is its relevance? Now, would you recommend someone to do or pursue a PhD, especially when that person does not want to pursue or build a career in academics? He doesn't want to become an academic. So what is the relevance like? And how does one go about it, especially when he's practicing law? And what are those circumstances in which the court can deny a matter referring to an arbitration? What is the effect of an arbitral award being set aside, and about the conflicting views of various decisions? So today we decided to seek assistance from someone who needs absolutely no introduction. Today we are joined by a very dynamic and a very prolific lawyer who's practicing before Honorable Gujarat High Court. So today we are joined by Mr. Anshul Shah. And just to give you all a brief introduction about our amicus for today's session, Mr. Anshul specializes in matters pertaining to environmental law, revenue, commercial disputes, arbitrations, trust act matters, cooperative societies matters. He's done his master's in international business law from the very prestigious NUS Singapore, and he's also completed PhD in the year 2021 from the Maharaja Sayaji Rao University of Baroda. And today we decided to seek his assistance on the reasons why people pursue. He will be giving and sharing his insights as to is this does this really help in practicing law? How does one go about it? So thank you, Mr. Anshul, for taking our time for doing this session. Anything that you wish to say before we start with our segment?
Thank you, Jay, for the lovely introduction. You put me on a pedestal. I don't know if I'll be able to live up to that, but I have been following your channel, and thank you so much for doing this for the younger generation, for people who are sitting at home and who don't have access to a lot of content. This channel is a wonderful way to provide that content to them, since the speakers on your channel are from such different dynamics. You have judges, you have lawyers practicing, you have lawyers doing litigation as well as corporate law. And I'm sure that we all stand to benefit from it. Thank you for doing this.
Well, thank you so much for that, for all those kind words. Well, two topics completely and totally poles apart. On one hand, our amicus would be discussing why one should pursue a PhD. What has his experience been like? Because he finished doing one in 2021. Does it really help in practicing law, especially when one does not want to build a career or pursue a career in academics or in academia? And on the other hand, there'll be a totally different topic, which will be on arbitration, and in particular, Section 8, in circumstances wherein the court or the judicial authority can deny referring a matter to an arbitration. What are the reasons like? So wow, this can probably only happen on the virtual amicus. So
Right.
Mr. Anshul, we can't wait to start with this segment. The stage is set. The floor is all yours. Over to you.
So thank you, Jay. In fact, right, just a little while ago, Jay was asking me if I'm a first generation lawyer or a second generation lawyer. And I was waiting for the session to start because it has a lot of, I'd want to share this with everybody. I am a second generation lawyer, but my father, he did his law when I was in school. He was earlier in the pharmaceutical industry, and one fine day he decided he's bored of his job, and he decided to start studying law. And it was a big step. I was in school, he had responsibilities. He started studying law. He was from a Gujarati medium school, and in order to help him out with his drafting eventually, my mother also started studying law so that she could help him out with his back office, with his drafting. And both of them went on to do their masters. Both of them eventually also went on to do their PhD in law. So there was a time when I was preparing for my 12th board exams, and my mother was preparing for her LLM finals, and my dad was preparing for his PhD viva. And so I guess there's academics always been running in the family. All three of us are lawyers, but everybody's always been interested in research, in academics. They were also visiting lecturers in the university. And that, I guess, had a lot to do with me also wanting to study more, do a bit more research, get in-depth knowledge about a particular subject that I'm interested in. So I guess that is what prompted me to also pursue a PhD in law. And when I was doing my master's, I had probably made up my mind then that I don't want to study more. I want to work. I want to see what it's like, because I was always interested in litigation. I was never interested in corporate law. And a lot of people were asking me at that time, if you are interested in litigation, then obviously, why would you want to do a PhD? isn't that just a waste of time? Because you can't focus on your practice while you're doing a PhD, not so much at least. And I didn't know the answer to that question myself till after I finished it. Uh, so if you are not interested in academics, yes, doing a PhD one might think is quite irrelevant. But when people do come to know, when you are before a court of law and when you are arguing a matter and the judge finds out that you have a PhD in a particular subject, on a legal subject, his whole outlook towards you changes. They start seeing you differently. Not the judge, not just the judge, but even the opponent lawyers, even your clients. When they see it on your business card, when they find out, their whole outlook towards you changes. They start treating you with more respect. They start taking you more seriously, especially for a young lawyer like you and me. It's very important that clients do take us seriously, because clients always want someone with experience. And for younger lawyers, it's difficult to find work, especially if you don't have a legal background. So doing a PhD does help in these two fronts, at least. One, people start looking at you differently. And two, your ability and your capacity to do research increases manifold. When you are in litigation, you know that you have to keep yourself updated with the latest developments. You must know the latest judgments on a topic. If you are arguing a case pertaining to a particular issue, it is best if you know what the Supreme Court or what the High Court has said in that matter on that issue. And when you are doing a PhD, you will go so deep into that subject, you will be virtually knowing everything there is to know about it. You would have read every single article, every single paper on that subject. And if that issue comes up before you as a matter, it will help. Trust me, it will help. So I guess even if you're not always interested in academics, but even if you decided you're going to do either corporate law or litigation, but doing a PhD does help. I don't know if it might be applicable for everybody, but for those who are interested in research, for those who want to develop a different thought-making process, for those who want to think outside the box, think about what, as your channel is all about solutions, for trying to find solutions, I guess that's where a PhD does matter even more. So I would encourage people to at least do their masters, if not their PhD, because both these degrees are basically, you do a lot of research. There's a lot of reading involved. And it's one particular subject. It's a core subject that you pick, a subject that you are interested in, or a subject that you wish you want to eventually practice in. So do a master's. Eventually, if you have time, do a PhD. And when I was doing a PhD, it was difficult to juggle litigation and writing a thesis at the same time. But since I'd seen my parents do it themselves, it was so much of an encouragement. It was so much better. My PhD guide, Dr. Namrata Solanki from the MS University of Baroda, she was very encouraging, very understanding. She knew that I am practicing in the court at the same time, and I might not be able to devote so much time to the thesis. But she kept on pushing me. She kept on challenging me with different ideas, different thoughts, ideas on which, subjects on which there is no research, for example, and on which if you were to write a paper, it would just be your own thoughts. So it's not about, it wasn't just me sitting in a library and reading books while writing a thesis. It was also me actually being in court, arguing matters pertaining to the same subject of my research. And I guess that is what made my research a little better. It is what I would have wanted it to be. I wouldn't just have wanted it to be bookish knowledge. Since I'm also practicing in the same subject, it mattered a lot when I attend an arbitration and I see what's happening, and I see how a particular issue is being dealt with. I see the judgments on that issue, and then I can incorporate the same in my research. So that did help a lot, since I was already practicing in that subject. And I guess that's why for me, doing a PhD has probably been one of the best decisions I've ever taken. No regrets. I spent 5 years doing it, but it was all worth it in the end when I got the degree. So that is something that I wish everybody at least thinks about it. You might choose not to pursue it eventually, but give it a thought. So, and it's also about the topic that you are choosing. It might be a subject that you are academically interested in, and something that you are academically interested in might be a lot different from what you are practicing in. So initially when I started my practice, I didn't have any arbitration matters. I was doing more on the revenue side, more on the commercial side. I did have a couple of small criminal matters as well, but this subject was something that I was always interested in. So I made sure that I compartmentalized the two. Your academic interests can be different from your career interests and your career goals, and that's all right, because there's something that you would want to read about in order to know more about it, and there's something that you would want to read about in order to help a client, in order to assist the court, in order to help you for your own arguments, and those two can be different things. It's all right. So doing a PhD did help in all of these things. It helped me understand the importance of research. It helped me understand that you have to develop your own thought process. It also helps you develop your arguments when you are faced with a new issue and you don't know what to say. You don't know how to convince the judge on a particular subject. Everything's against you. The judgments are against you. But when you've done so much research on a subject, it it motivates you to figure out how to come out of a problem and what best solution you can find for your client. I am interested in academics, not so much. I love litigation, but I guess I might never go into academics. And but that was never one of the reasons why I thought, oh, a PhD would be irrelevant. At the end of the day, it's just research. It's just knowing more about a subject that you're interested in. And it matters when people find out that you have a degree, when you have a doctorate, their whole outlook towards you changes. So I guess that's about doing a PhD in law while doing litigation, knowing fully well that you might never enter into academics.
So as far as the first topic is concerned, doing a PhD, broadly, to sum it all up, academic interest can be different from your professional expertise, because on the professional front, your expertise is determined by the number of clients that you have in that very field. So
And
there's
the
a
matter.
huge field. Exactly. So that can obviously vary, and it's always good to pursue, to be inquisitive, to find out things that you've never dealt with before. That makes your practice even more interesting, and it's always good. I mean, it reflects on your profile every time you plead or you make submissions in a court, and if the judge knows that you've done a PhD, respect goes all the more,
Yeah.
a notch higher. And it does make a lot of difference, especially on your visiting card, when you hand it
Yes.
over to the client who's referred a matter to you. Then it would definitely have an impact, and that's a testament to the fact that you've achieved something in academics, which will
Exactly.
which is of a huge worth. So yeah, I mean, that was like an amazing insights coming in there from our Amicus. A heart to heart conversation is something that always helps viewers, because so only when you ask questions, you get answers to those questions. So now that we're done with our first topic, coming to arbitration, totally different from
Yeah.
what we just discussed. So you'll be covering the effect of an arbitral award being set aside in the conflicting views. So
Hmm.
now the stage is set. The floor is all yours. Over to you.
So we know Section 34 of the Arbitration Act deals with setting aside an arbitral award. And what happens when an award is set aside? You have very limited grounds to challenge an arbitral award. You can't challenge it on merits, and you have really limited grounds. When an arbitral award is eventually set aside, most of the judgments in our country say that the parties are relegated to their original litigating position. They are free to begin arbitration again. Res judicata doesn't apply. The period of limitation goes, and parties are put back to square one. But here's the question: is this what was the main objective of arbitration? you're trying to reduce workload in the courts. You're trying to obtain a faster, speedier justice delivery system, a dispute resolution mechanism. And the parties go through the entire gamut of everything. They go through the whole process. Arbitration takes place, arbitration's over. You've paid the arbitrator, you've paid your lawyers, you've had these arbitral sittings in 5-star hotels. And at the end of the day, when a Section 34 application is filed by the losing party before the tribunal, the award is set aside on whatever grounds. And then the parties are back to square one. Now, this is not what arbitration was about, because you have no end here. If the parties begin an arbitration all over again, and if the award is set aside again, then parties are relegated back to their original litigating position. It's like a vicious cycle. It's an endless loop. Where does it end? This isn't the same in litigation. When you are filing a suit, say for example, if you have filed a suit, there is an application under Order 7, Rule 11 for rejection of plaint, and that application is allowed, and your suit is dismissed, and you file a first appeal before the High Court, and then your first appeal is allowed. That would amount to the order under Order 7, Rule 11 being quashed and set aside, and your plaint being restored. So the question that I would ask myself is, if I am a claimant before an arbitral tribunal, and if the arbitral tribunal rejects my claim, and I challenge that award under Section 34, and if the Section 34 application is allowed, the question is, does it tantamount to my claim being allowed? But the obvious answer is yes, but the judgment say no, because parties are relegated back to their original litigating position. So there is this one judgment of the Delhi High Court, which takes a very, very interesting view. And I'd love to read out a couple of paragraphs from that judgment. It's in the case of Bharti Airtel versus Union of India. It was a judgment delivered by the Delhi High Court in May 2016. And some very interesting observations in that judgment. So let me just, yes. The court says in para 16 of that judgment, I have wondered whether the setting aside under Section 34 of the Arbitration Act of the arbitral award amounts to the petitioner being entitled to refund of the license fee for that period, so and so. In my view, once the parties go to arbitration on a question whether one party is entitled to the monies claimed from the other or not, and the arbitral award not finding that party to be entitled to the monies claimed is set aside in exercise of powers under Section 34, the order of the court has but to be read as finding that the claimant party to be entitled to the monies claimed, unless the arbitral award, just a second, unless the arbitral award not finding that, unless the arbitral award has been set aside on technical grounds. So I'm just going to translate in simpler terms. The court says that when there is a money claim and the arbitral tribunal finds that no, the money claim is to be disallowed, the money claim is to be rejected, and then there is a Section 34 application which is allowed, then it would tantamount to the original claim being allowed. So to give any other meaning to the order of the court in exercise of power under Section 34 would severely undermine prejudice efficacy of arbitration and would lead to arbitration ceasing to be an alternative dispute resolution mechanism. Now, this is something very important, what the court says here, because this is falling straight from the mind of the judge. He then goes on to say that it cannot be lost sight of that the court in exercise of power under Section 34 of the Arbitration Act has not been empowered to set aside an arbitral award on merits of the claim. The only ground besides the technical grounds enumerated in Section 34(2)(a) or Section 34(2)(b)(1) on which the court has been empowered to set aside an arbitral award is the ground of the arbitral award being in conflict with the public policy of India. Now, this public policy is huge. The scope of these words is huge. The expression public policy has been held to mean the fundamental policy of Indian law, justice, and morality. Once the court in exercise of power under Section 34 of the Arbitration Act has set aside an arbitral award rejecting a monetary claim on the ground of the same being against the public policy of India, as the arbitral award in the present case has been set aside. The necessary corollary and inference in my opinion, is that the court finds the award rejecting the monetary claim to be contrary to law and resultantly finds the monetary claim to have been proved and established. If it were to be held otherwise, and it were to be held that the order of the court means nothing more than setting aside the arbitral award, rejecting the monetary claim, and it would leave the claimant who applied under section 34 and succeeded therein, in spite thereof, being left high and dry without a relief, which makes complete sense. Because when a section 34 application is allowed, it would naturally tantamount to my claim being allowed. But most of the judgments, even of the Honorable Supreme Court, are that no, the parties are free to begin arbitration again, or it won't operate as res judicata. They'll be relegated back to their original litigating positions. And the court does come to the conclusion, even after this, the court observes that though I am bound by the dicta of the division benches of this court, as well as the Supreme Court, let me just read that paragraph as well. Yes, I am further of the opinion as aforesaid and strongly feel that to so leave a party whose claim has been rejected by the arbitral tribunal and who succeeds in having the arbitral award set aside on merits in a petition under section 34 in a lurch would make a mockery of arbitration, defeating the very purpose thereof as an alternative dispute resolution process, and make the same very lengthy and costly. So it's, there's this one judgment on one hand of the Delhi High Court, and you have a number of judgments of various high courts and the Supreme Court saying that when a section 34 application is allowed and the award is set aside, nothing happens. But this one judgment is food for thought. It really brings out what was in the mind of the judge. It really echoes our sentiment as well, because the Arbitration Act is silent on this. It is not just the Indian Arbitration Act. The English Arbitration Act, the Canadian Arbitration Act, the Singapore Arbitration Act, all of these acts are silent as to what happens when an arbitral award is set aside under section 34, corresponding to their relevant sections. Nothing is there. Even in the model law, which is the fundamental basis on which all of these arbitration laws have been prepared, even the model law is silent on the effect of an arbitral award being set aside under 34. So, and we know that an arbitral award cannot be set aside in part. It has to go as an entirety. So even if on one issue, the court finds that yes, the award has to be set aside, the entire award goes. And it is when the whole purpose and the whole object of arbitration was that it is a speedier dispute resolution mechanism. If this exercise continues, how long will the party do it? He's a claimant or a respondent, goes before the arbitral tribunal, then goes before the district court in a section 34 application, then would challenge that order before the high court, then would go to the Supreme Court, and then it would just, the whole cycle would begin again if the court comes to the conclusion that no, nothing happens. The parties are relegated just back to their original litigating position. So I guess this is where we need to have a lot more debate on this issue. We need to understand what the objective behind the act was. The intention of the legislature was definitely not to get parties stuck in this loop. The intention of the legislature was to get a speedier solution. And if the court finds that yes, a section 34 application has to be allowed and the arbitral award has to go, then that has to have a resultant effect. A party who has won before the court deciding the section 34 application has not won. He's left with nothing apart from his claim, which yes, is not barred by res judicata, but what importance is that to him? So I think this view taken by the Delhi High Court is really something that is extremely progressive, since we are talking about a lot of judgments, where we are not interfering with arbitral awards. We are making sure that enforcement happens. We are not stalling enforcement. And this view taken by the Delhi High Court in my opinion, is the correct view. And we need to talk more about, and we need to do a little more research on this as to under what circumstances, when a Section 34 application is allowed, whether the party who has won would eventually be entitled to some relief. You can't expect a winning party to be left with nothing but a pending claim. So this one judgment in the case of Bharti et al. Versus Union of India by the Delhi High Court in 2016 is where the judge has in fact voiced his own views and said that I know, but I am bound by the other judgments of this court. But this view makes a lot more sense, but I can't take this view. And the judge says that in the judgment in extremely clear and unambiguous terms. And I think it is a very important judgment, extremely progressive, and maybe, who knows, eventually somebody else might decide to do a PhD on this subject and we'd have a lot more research on this subject.
Well, definitely, I think it's always been a boon for lawyers, but a bane for the client, because this was never. It was always good for lawyers to fight it through till the very supreme, the last court, the highest court, the law of the land, honorable Supreme Court, and the intention of legislature obviously was not to get this entire cycle entangled and get the lawyers and the litigants, the stakeholders get stuck in that loop. The intention was to make it cost effective, to make it speedier, but I think it has now become a luxury. Especially the cost effective part has been totally sabotaged
It is
by what we've
luxury.
seen so far. It is definitely a luxurious litigation. It's a form of a luxurious litigation, and there's no finality. Even when an award is passed, you see at the drop of a hat, Section 34 objections being preferred, and then once they are dismissed or there's an adjudication type place, then appeals, then High Court and Supreme Court goes on, and that is how it is. So probably a discussion, an intense brainstorming is required between all the stakeholders. Probably Parliament has to, there has to be some debate happening on this, because this can go on forever, and we will never see the effect. The effect of that award is never seen. The execution, the effect, because ultimately it is always been subjected to some challenge or the other in some forum.
Right.
And even if the passing or enactment of the MSME Act or Commercial Courts Act for that matter, I don't think it has done anything productive apart from redesignating the same district judges as commercial court judges. I mean, they are holding the same position. They were holding the same position back in the day in civil courts. And now they're only, the terminology has changed. The functions and everything remains the same. So I think there has to be some brainstorming there. I mean, such amazing insights coming in there from our Amicus for today's session. Probably, a viewer can think of doing a PhD on this field, and especially the landmark ruling that you mentioned delivered by the Honorable Delhi High Court. Now, Anshul, if you have the time, we can still cover topic 3, and you can just skim through certain things. Totally up to you.
So,
about the reported judgment that you had mentioned, and anything that you wish to say in circumstances when the adjudicating authority can deny a matter being referred to an arbitration, in a nutshell. Yeah.
Yes. So what happens is we need to remember that there are a lot of obstacles that come in the way of parties wanting to go for arbitration. When there is a suit that is filed and a party wants that matter to be referred to arbitration, the court will have to look at Section 8, Clause 2. And there are various circumstances where you can avoid, as a lawyer representing your client, from the matter being referred to arbitration if you have filed the suit. And mostly in commercial disputes, say for example, there's a partnership dispute and you have alleged that the partner has sold off the property, that there's some fraud that has taken place. Earlier, the position was such that when issues pertaining to fraud have been raised, the arbitral tribunal wouldn't have jurisdiction. And now the powers of the tribunal are widened. They have more scope to look into it. Mere allegations of fraud will not be enough for an arbitral tribunal to say, I don't have jurisdiction, or for the court to say that, no, we can't refer the matter to the tribunal. But when, so this case that was there, it was a very interesting issue because the suit that was filed, there were various respondents. Most of them were partners of the partnership deed. But there was one respondent who was the sub-registrar who had registered the sale deed. And there was a specific relief claimed against the sub-registrar, which was for cancelling the sale deed. Now, there was an arbitration clause in the partnership deed. But when there is this respondent, the sub-registrar, who is not a party to the arbitration agreement, how do you refer that dispute when there are certain reliefs claimed against that person? So lawyers can, smartly, cleverly draft their claims in such a way, if they want to get outside arbitration, if they want to drag the party to court, this clever draft can help. You add another party, you claim some relief against them. Eventually, you would have to argue that the reliefs that are claimed for are beyond the powers of the arbitral tribunal. The arbitral tribunal cannot direct the sub-registrar to cancel or nullify a sale deed. So these are the issues which would come eventually in that case. And just by adding another party, you would be able to take the defense that that party is not a party to the arbitration agreement, and therefore no arbitration can take place, which is something that we can also explore as lawyers.
Fantastic. So there you go. That was very dynamic. Anshul, who joined us from Ahmedabad, technically first lawyer speaker who joined us from Gujarat. Thank you so much, Anshul, for taking out time for doing sessions on these three totally different topics that were poles apart, from PhD to arbitration to circumstances in which the court can deny referring a matter to an arbitration. Well, it can only happen on the virtual Amicus, and thanks to you for that. Anything that you wish to say as parting words before we wrap this up?
I thank you for this opportunity, Jai. First of all, it was lovely being here. It was a privilege to share all these things, because normally I wouldn't get a chance to share all of this. It would only happen if I was in academics and I would have an audience in front of me who would be listening to what I say. But so thanks for this opportunity. I hope that people do consider doing a master's, or for those who have done a master's, to consider writing papers, writing articles, or doing a PhD if that appeals to them. It does help in research. Apart from that, as far as the second topic that we were talking about goes, I hope that more and more people speak about it. We need to have some sort of understanding as to what happens when an arbitral award is set aside, and the viewers on your channel would maybe come out with something very different, and let's hope for the best. I hope that everybody had a good time listening to the talk. I hope it wasn't boring, but yes, thank you.
I think to add to that, for example, if objections are dismissed, and let's say the application under section 34 is dismissed, then something probably as an interim measure can be given, probably 50% or 40% of the amount that the parties have won before the tribunal. Something of an interim benefit, I think, can probably suffice, the whole purpose of this passage of act. Probably one of the, possible solutions could be that. So there's this brain just.
The party that has eventually succeeded in the section 34 application gets something.
Something, in some form or the other. Right. So there you go. Thank you so much, Anshul, for doing this session. To all the viewers who are watching, our email is mentioned on the channel in case if you have any queries on the PhD program, how to pursue, what not to do, what to do, when to pursue, can you pursue it while you're practicing law, the advantages, everything for that matter, feel free to write to us. We'll be more than happy to forward the same as it is to our Amicus for today's session, Mr. Anshul Shah. And you can write to us whenever you want to. And thank you, Anshul, once again. It was an absolute pleasure recording this session, and it's goodbye for now. Thank you.
Thank you. Bye.